9 petitions and a flood of responses, many of them with a heavy dose of controversy, and all packed in a short span of 6 days or so. Good evening. My name is Sam Gituku, and this is the state of the race. Eminent advocate of the High Court, Senior Counsel Charles Kanjama, is with me tonight to make sense of the heady week, bulky documents, and the presidential election petition proper, which is coming up in open court at the Supreme Court. But before we go to the petitions, we have elections, and I'm talking about the pending ones to be conducted in some 8 electoral units that include Mombasa and Kakamega counties and a number of constituencies and wards. In Mombasa County, some 641,000 registered voters are expected to elect their governor from a list of 7 candidates in the race. Of course, you're talking about Hezron Awiti from VDP, Hassan Omar from UDA, William Kingi of Pamoja African Alliance, Daniel Kitsawa, an independent candidate, Shafi Makazi of Upya Party, Abdul Somad Nasir of ODM, and Said Omari of Usawa Political Party. Similarly, in Kakamega County, over 844,000 registered voters are expected to go to elect who will be their governor from a list of 7 candidates. We're talking about Fernandez Baraza from ODM. There's also Wan Huajirongo from UDP. There is Suleiman Kanyanya of KANU, Cleophas Malala of ANC, Samuel Omukoko from MDP, Austin Opitso, an independent candidate, and Michael Sakwa, also an independent candidate. But in the parliamentary elections, that is the races in Rongai constituency in Nakuru County, they will stage a 3-way battle with candidates Paul Chibor of UDA, Luka Kigen of Chama cha Mashinani, and KANU's Raymond Moy squaring it out for the member of National Assembly seat. In Kitui Rural constituency, it is a 2-horse race between David Mboni of Wiper Democratic Movement and Charles Nyamai of UDA. You can see them there on your screen. Now in Pokot South constituency within West Pokot County, David Kosing of the Kenya Union Party is defending the seat in a contest with Simon Kalekem of UDA and James Lopoyetum, an independent candidate. In another race that is in the neighboring Kacheliba constituency, there are 3 candidates. You're talking about John Lokitare of KANU, UDA's Mark Lomunokol, and Titus Lote of the Kenya Union Party, that is KUP. Now, Interior Cabinet Secretary Dr. Fred Matiang'i gazetted a special and can I say area-specific public holiday to facilitate the conduct of the delayed polls tomorrow. Schools in all the areas holding elections tomorrow will have been closed for the day. And Charles, when you look at this, of course, we know that initially the elections are supposed to be conducted on the 9th of August. That was postponed to 23rd of August, then eventually to be tomorrow, the 29th. Do you think in the circumstances that the country finds itself in, that IEBC has done the best it could to give an opportunity to the residents in these areas to cast their vote?
I think the residents of those areas would have preferred to have the election even within a week, and now it is going to be 20 days. But we have seen IEBC facing numerous challenges in tallying and verification of presidential election results and results across the country, and now having to coordinate their responses to the presidential election petition. And this is in the midst of division that you're finding between the commissioners. So I think IEBC has ultimately dealt with the various internal and external challenges, and it has now given the voters an opportunity at least to select their representatives. So I think on a score of 1 to 10, I would give them 6 on their effort to at least hold the elections after they bungled them on 9th of August.
Whoa, that's a heavy word to use. But away from those elections, let's get back to Nairobi, where you're talking about the Supreme Court battle that will be happening. Of course, starting this week. We are talking about, so far, there are some 9 petitions that have been filed before the Supreme Court. And these are the petitioners: Raila Odinga with Martha Karua in 1 petition, Okiya Mutata and 3 others. There's David Kariuki Ngare with another petition, John Joroge Kamau with another, Julia Nyokabi Chege and 2 others have a petition. Helef Khalifa and 3 others have a petition as well. Ruben Kigame, who is a former presidential aspirant, also has 1 petition. Youth Africa Advocacy Africa plus 1 other person also have 1 petition. And of course, you're also speaking about the former Gatundu South Member of Parliament, that is one Moses Kuria, with 1 other who has already filed a petition opposing the claim by one Raila Odinga in court. But if you're talking about the respondents that are involved in this particular petition, let's just get them. We have IEBC as an institution, of course, that is the Independent Electoral Boundaries Commission. There is the chairman, Wafula Chebukati, who is the Presidential Election Returning Officer. The 6 other commissioners are unusually listed as respondents in that particular case. Of course, you can see them from Commissioner Boya Molu, Abdi Gulie, Juliana Cherera. Then there is Irene Masit, there's Justus Nyangaya, Francis Wandera, as individually they have been filing their responses to that particular case. We also have the respondent in the name of William Ruto, who has also been listed as a respondent, and we'll be getting to the details about that later on. But the other respondents that have been listed by some of the petitioners, you have Rigathi Gachagua, who is the Deputy President-elect. There is Raila Odinga himself. He is running mate, Martha Karua, the Attorney General, and Azimio la Umoja Party. And again, like I said, we'll shortly be looking at some of the issues of determination in the petitions. But first, let's speak to Charles. And when you look at this, of course, on all these many petitions that have been filed, so many issues at hand, and of course, the court is like, what is the court likely to do in as far as the efficient management of these petitions, bearing in mind the voluminous nature that you're seeing?
Sam, I think the court will follow the precedent that it set itself in 2013 and 2017. There was more than one petition in both cycles. They consolidated the petitions. They summarized the issues into about 3 or 4 major issues. Maybe this time they might find 5 or 6 major issues. They'll allow those who are supporting the petitions to submit jointly, and those who are opposing the principal petitions to submit jointly. So, for example, Raila Odinga is a respondent in Moses Kuria's petition, but is fundamentally a petitioner or is supporting the overturning of the results. So probably he would be on the side of the petitioner. They would have the first go or the first bite at the cherry. Then those who are opposed to the overturning of the results, that is mainly IEBC and William Ruto, would go after. In regard to the commissioners who are split, I guess the Supreme Court will have to decide whether to listen to them at the same time or to listen to those who are supporting the petitions with the petitioners, and then those who are opposing the petition together with the other respondents.
And it's interesting that you point that out, because there's that question about the commission has had 2 submissions, one filed through Hussein Marjan, who is the CEO, and another that was filed through Issa Mansour, who is a lawyer, saying that he's sort of representing the 4 commissioners within IEBC. So what is admitted by the court? What gets admitted?
So normally in court processes where you have 2 advocates claiming to represent the same party, the court would first want to resolve the question of who is the advocate rightly representing the party, who has the authority to represent the party. That may require the court to give a court decision or ruling before going on to hear the main petition. But because of the tyranny of time that we are facing in these petitions, it is also possible that the court could decide to reserve that question for determination in the main decision and to allow both parties to submit. So we'll wait to see what direction the Supreme Court judges take.
Okay, and you're speaking about what the filings have been. And I want us to take a moment to understand a part of the content that has been contained in those petitions. And of course, these are the petitioners that I was telling you about, but a read through will show you that there are certain recurring issues. They're talking about, for instance, David Karaoke and John Njoroge, Julia Nyokabi and Halef Khalifa, just to name a few, cite the claims by 4 of the IEBC commissioners that Chairman Wafula Chebukati acted alone. They're also saying that Juliana Cherera team of 4 commissioners disowning the results declared by Chebukati, and that presidential election results from at least 27 constituencies were never announced at the Bomas of Kenya before the final declaration. Those are just some of the bases that have been contained in some of those. And then some of the petitions are also citing that the postponement of the governorship elections in Kakamega and Mombasa and 4 parliamentary elections hampered the voter turnout in those areas. And of course, saying that they affected the presidential election voter turnout, so to speak. And of course, they're also adding that the question about, he claims that, this is Halef Khalifa, claims that the election technology was compromised with the possibility that the election results from polling stations were interfered with. Khalifa raises a unique question across all the petitions, once you read them, saying that the KPMG's audit report was never implemented by the IEBC. It was never made public, and therefore saying that he claims that the audit report, for it not being made public, sort of affects the credibility of the voters' record. The other question that is about the petitions that is one to do with the new Busia senator, that is Okiya Omtatah, and 3 other petitioners have raised questions the issue of voter turnout, which he believes was at 65.4%, as announced by Chairman Wafula Chebukati on August the 10th. Based on the final IEBC data, the turnout appears to have settled at 64.77%. Omtatah further questions what happened to the difference, which he puts at 140,000 untallied ballots. So we'll get shortly to what Raila Odinga and Martha Karua petition. But first, Charles, if you're to look at this, already these are very technical issues that are being raised and will be raised before the judges. So how do the judges come to understand all this and make a logical decision in areas that they're not necessarily experts in?
Okay, so first of all, the judges are going to compress all the various grounds and join the ones that are similar, like the ones raising numeric questions, the ones raising technology questions, the ones raising the legal question of the role of the chair and the role of the commissioners of IEBC. So they're going to consolidate them. The judges tend to be assisted by the evidence that is presented by the parties. The parties have their own experts who have presented affidavit evidence. There may be other experts who come in as amicus curiae, who the court will also listen to. So the courts are experts in analyzing evidence and applying the law to give an outcome. So the judges don't need to be experts in all areas that are raised in the petition. For example, they don't need to be technology experts, but they'll read the affidavits of the technology experts. They'll interact with the lawyers when they have questions that they need to have answered. And through that, we can have confidence that they will grasp all the issues, understand them, and give a judgment that hopefully will be for the best interest of the country.
So how do they know who is telling the truth?
Ordinarily, judges use the process of examination and cross-examination and re-examination, which is led by lawyers, to test the veracity or the truthfulness and the strength or the cogency of the evidence that is presented by different parties. And by looking at evidence of one side and another side and comparing the evidence and contrasting it against all the other information that has been presented, the judges can assess what we call the probative value. In other words, how much the evidence is strong and how much it helps you to prove the case that you are seeking. In this particular matter, because there's no cross-examination, the judges will have to rely on affidavit evidence and compare and contrast. The affidavits come with supporting documentation, and judges are trained in the art of analyzing evidence and hopefully discerning who's telling the truth.
Okay, all right. Now, back to the petitions. Raila Odinga and Martha Karua agree with petitioner Okiya Omtatah. They have complained of the inconsistent voter turnout numbers that they say has never been settled. They say that even if the final valid votes cast per candidate were to stand, the threshold of 50% plus 1 was not met, and were the voter turnout question to be resolved. The petitioners claim that there was manipulation of Kim's kit data, and they question the role of some Venezuelan nationals that were arrested at few weeks before the election at the Jomo Kenyatta International Airport in possession of some materials relating to the elections. Now, Odinga and Karua claim that Forms 34A were manipulated while on the portal, citing an agent of William Ruto. So, those are the basis of the petitions contained in submissions and the petitions themselves. The respondents had until yesterday to file submissions. Commissioner Justus Nyang'aya, one of the 4 IEBC commissioners that disowned Chebukati's announcement, has filed what looks to beef up the case of petitioners. Commissioner Nyang'aya agrees that Chebukati acted alone to the exclusion of commissioners that he serves at the but also that he serves at the commission as the chair of ICT committee, but was kept in the dark in any technology issues from the date of the election, that is on the 9th of August. Nyang'aya claims that he was pushed to managing protocol issues, in short, handling very important guests at the Bomas of Kenya. Nyang'aya, who is the chair of the IEBC ICT committee, says that a foreigner whom he names had access to the IEBC server since the 1st of June this year up until days after the election. He claims that that foreigner and some IEBC staff that he also names replaced results declaration forms on the IEBC portal. And now President William Ruto has also responded to the case, and he is saying that that is to the petitions accompanied by several affidavits as evidence against the petitioner's claims. Ruto, in documents filed in court, says that Odinga lacks any genuine grievances and that the petitioners are relying on falsified logs to claim penetration of the IEBC systems. Ruto says that IEBC tallied results in the presence of agents representing the presidential candidates, and that verification of results was based on the original forms and not those on the IEBC portal that petitioners now are claiming were interfered with. Ruto also says that the said ICT agent claimed to have penetrated the IEBC system told him how impossible it is to alter and dump some 11,000 from 34As as alleged, and do that within a record 8 minutes. So what is the IEBC chairman, that is the presidential election returning officer, saying? That is Wafula Chebukati. He is saying that that is in an affidavit that he filed, which has opened the lid on the happenings of the day of the announcement of the final presidential election results. Chebukati says that he received unlikely visitors at 3 a.m. on the 15th of August. And of course, he says that the visitors were Azimio la Umoja Executive Director Raphael Tuju, Senator Amos Wako, and Advocate Chalo Mbobu. And of course, we know that Raphael Tuju now says that that meeting may have happened, but it was not 3 a.m., it was 4 a.m. Get the difference? Now, what did they want? Chebukati says that Senator Wako told of looking at the bigger picture in declaring an election outcome, that Tuju asked for what he termed as moderation of the election results in favor of Raila Odinga. Chebukati claims that Tuju asked that were that not to be possible, then at the very least the commission should force a runoff. Chebukati says that Commissioners Juliana Cherera, Justus Nyang'aya, Irene Masit, and Francis Wanderi agreed with Tuju and Wako, but added that he and Commissioners Abdi Gulie and Boya Molu rejected that request. So let's focus on something else. Chebukati has told the Supreme Court that he later that day received a delegation from the National Security Advisory Committee of Kennedy Kihara, who is the Principal Secretary at the Office of the President, Kennedy Ogeto, who is the Solicitor General, Hilary Mutiambai, the Inspector General, and of course Francis Ogola, who is the Vice Chief of Defense Forces. Chebukati claims that the spokesperson of that delegation was Kennedy Kihara, who cautioned of likely chaos were Ruto to be declared president-elect, that Kihara asked the commission to cause a runoff if it was impossible to declare Raila as the outright winner. Chebukati says that 4 of the commissioners agreed with the remarks which Gulie and Molu differed with. And of course, Charles, as we look at all this, obviously the question that Kenyans have been thinking is about what could have happened at the Bomas of Kenya. And looking at some of those, or rather those issues, how then, especially when you have the IEBC Commission, I know you had touched on this earlier on, you have an institution that is coming before you. First, their decision is being challenged. Part of the commission is agreeing with the challenge. The other part is defending it. How difficult is it for IEBC, and how difficult is it for the court to know who is telling the truth and determine whether the election should be invalidated or declared valid?
First, let me say that what happened in Chebukati's office, or what did not happen in his office, is not what will ultimately determine the case, because it seems to me that this case is about the votes that were tallied in the plenary at Bomas. But what happened in Chebukati's office is important circumstantial evidence that will help the court determine who is likely telling the truth regarding other aspects of the case. Of course, it will be very difficult because we'll have parties who are disagreeing, who've been working together in the IEBC Commission. They have even instructed different sets of lawyers to represent IEBC. So that's going to be a challenge. But I think the court has faced this kind of situations in the past. I must say that even in the Law Society of Kenya, where I'm a member, a few years ago, we had a similar situation where the council, which is the body that runs the Law Society of Kenya affairs, was split down the middle. You had one faction that was led by the president. You had another faction, which was a majority faction, led by the other council members. And the judges were able to go through or discern through that entire mess what, according to the judges, was the best course of justice and get the evidence from both sides to be presented and then to make a determination looking at the law that constitutes that particular body or organ and to make the determination. So I believe they'll be able to do it, even in this case, even though they have very little time to do so.
Right. Okay. Of course, we'll wait to see what happens. And I want us now to focus on some of the key prayers that are being sought before the Supreme Court. Odinga, for instance, wants the Supreme Court to nullify the election of William Ruto and Rigathi Gachagua. He wants the court to direct IEBC to tally and verify the presidential election count, and that IEBC declares Raila Odinga and Martha Karua as president-elect and deputy president-elect, respectively. Odinga is also wants the court to declare that IEBC is, as currently constituted, incapable of presiding a proper presidential election. He also wants that all votes affected by irregularities be declared invalid. The other question is that Deputy President William Ruto, who is also the president-elect, wants the court to dismiss the petitions and to award costs to him. And of course, looking at some of these prayers, Charles, is it possible that a court, the Supreme Court in this case, can actually shift the decision on who the president-elect is to someone else, as prayed by Raila Odinga?
It is possible, but not probable. So possible means it can happen, and there are situations which have been indicated in the Elections Act. That is when the court does a recount or a retally and discovers that there is an evident mistake. The rest of the substratum of the elections was done in a free and fair way. There were no major irregularities. It was only a counting error. So if the court now does the recounting and finds that actually so-and-so should have won, this was just a kind of like accidental mixing up of the numbers, the court can declare a different person as the winner. And that has, I think, happened in previous elections, not at presidential level, but it's quite rare. So it can happen, but it's rare. What we've seen in the Raila Odinga petition is that they have not just challenged the count. They've raised several irregularities, questioning even the Form 34 is. So when you go to the underlying questions and you challenge even the free and fair manner in which the elections were had, then the court is unlikely in such a case to declare a loser as a winner, because it means you are challenging the entire process of counting, transmission. If the court agrees with you, they'll probably just say, let's do a repeat election.
Interesting. Now, let's take a look at something else that we need to do, and this is how the legal battle looks like. And it's literally sort of a legal battle. I hope I'm allowed to call it so. And this is what is happening. We know that the petitioners, Raila Odinga and Martha Karua, have listed a team of 42 lawyers, some of them senior counsels. Respondent William Ruto has listed a team of 54 lawyers, while the IEBC chairman, Wafula Chebukati, has listed some 15 to 18 law firms, that is from the IEBC, but also we know from the information that came today or yesterday that also the other commissioners are also being represented by different teams. Now, Odinga's legal team is led by the senior counsel, that is James Orengo, Feroz Noroji, Philip Murgo, and Okongo Omogeni. Now, for the other side, of course, there are those other 38 others. So for the side of William Ruto, the legal team is led by senior counsel Fred Ngatia, Kioko Kilukumi, Professor Kithure Kindiki, and Kiragu Kimani. Now, when you look at so many lawyers, I mean, in their numbers, you also look at the evidence that was being taken before the Supreme Court. Azimio Moja arrived there in a truckload of documentation. We saw the Kenya Kwanza arriving there with just a box of evidence. What out of this is just game of, is it mind games? And what is useful in all this documentation, but then also with all those many lawyers, who gets to speak to the judges? Okay,
first, Sam, it's important to have a strong legal team. You have only 2 weeks to handle a massive presidential election petition. There's tremendous evidence. There's a lot of work that is done behind the scenes in the offices, and this work has to be divided between lawyers. So the lawyers are not just being put there for show. I believe they're actually working very hard in support of their teams. And because they have different roles, not all the lawyers will speak. Generally, each legal team will want to have their main lawyers doing the speaking. So some of the senior counsel, the more experienced lawyers, but they could also allow some of the younger lawyers to have an opportunity, especially on specific aspects where the lawyers have addressed themselves and done the research. So each team will have to make the determination. It's interesting that some of the lawyers in the legal teams are now newly elected governors, and the court will have to determine whether Article 77, paragraph 1 of the Constitution, which says that a full-time state officer cannot have gainful employment, whether it might come into play. I know this happened before when you had senators and members of National Assembly representing parties in court, and the court said that those were not full-time positions. But I don't know whether that will also apply for governors. So that will be one of the issues to be resolved. But the evidence that is presented in boxes, it doesn't mean that the judge will read each and every page. A part of that evidence is reference material. They'll focus on the core pleadings, that is the petition or the response. They'll focus on the affidavits, which contain the principal evidence. And then when they need to refer, they'll refer to the supporting documentation. And each judge does not act alone. They have teams of researchers that assist them in doing their work. To pour through the evidence, so that by the time even they are doing the hearing of the case, they already have a fairly good idea of what the evidence is, what are the legal issues at play. So it's going to be intense, sleepless nights for the lawyers and even for the judges who are participating in these proceedings.
Okay, very interesting. And I want us to conclude by looking at the road ahead. He's just mentioned about the very intensive week that we're just about to have. Tomorrow being the 29th of August, this is the time for interlocutory applications to be filed and served. Then the following day, there should be responses to those applications. On the same day, there should be the pre-trial conference or the case management conference, and it is likely that the hearings could begin on that day. It is up to the court to decide how many days they want for hearings, how to share that time between the petitioners, the respondents, and whoever else will be party to that case, including those that are seeking to join the court as friends of the court, who will be applying on the 31st of August to be admitted. And then by the 5th of September, the verdict has to be delivered to the country to inform the next course of action in as far as whether it is proceeding to assume office or is to return to the election based on whatever the judges will decide. And that brings us to the end of the state of the race tonight. I must thank our guest, Senior Counsel Charles Kanjama. There are people who are asking that you now became a Senior Counsel. They don't know. You want to tell them?
Well, yes, I did. The court, it's a process that involves a committee, the Senior Counsel Committee. It involves the Chief Justice, the President of the Republic, and then eventually sign the roll. So that happened, I think, a week ago eventually.
Okay, all right. Congratulations for that. My name is Sam Gituku. Thank you so much for watching State of the Race. Up next, Kenya's Choice continues with Jeff and Vicky. Bye for now.